Hello, everyone. Thank you for joining Jennifer Schaus and Associates in our complimentary webinar series for U.S. federal government contractors. We're coming to you live from Washington, D.C. today. This webinar series will run for 15 weeks or on 15 Wednesdays as we cover subcontracting opportunities within each of the 15 federal departments. As usual, all webinars are complimentary. You can find the schedule, registration links, and the recordings on our website under the subcontracting section. Our data partner each week is GovSpend, formerly FedMine, and our legal perspective will be covered by a rotating government contracts attorney each Wednesday. So a little bit more about us. As you can see on the slide, we provide the following services for federal contractors, including product, service, and software firms across the globe. You can find more information about us on our website. Our webinars and newsletters reach a vast array of federal contractors, and our YouTube channel now has almost 600 complimentary webinars. We're adding to that each week, so please give our channel a like, follow our channel, and give our videos a like or a comment. We also offer advertising opportunities, including in this series. So if your organization is interested in reaching federal contractors, you can sponsor an event, our webinars, advertise in our newsletter, or have us post your promotional information on LinkedIn. Contact us at hello@jenniferschaus.com for pricing and our media kit. Please join us on Monday, December 12th at the Kennedy Center for our annual holiday soiree. We expect over 200 attendees. Federal departments and corporate sponsors will be announced as they confirm. You can find the registration links within this PowerPoint after today's presentation and also on our website under the Events tab. And now we'd like to take a moment to thank the organizations that help make this series possible. A special thanks to Tom Johnson and the team at Set Aside Alert for posting this webinar series in their newsletter. Please visit setasidealert.com to learn about their services for small businesses. Additionally, we'd like to thank GovEvents and also Fairfax County for sharing this webinar series on their public calendars. Please visit their websites and calendars for other related events. Next, we'd like to thank the Virginia PTAC. Virginia PTAC is based out of GMU in Fairfax, Virginia, and offers free one-on-one counseling on federal, state, and local procurement topics. Online resources and group trainings are free with no restriction on your business location. If you're interested in learning more, please use the links provided to contact the PTAC. And also thanks to our friends at BidSpeed. The BidSpeed platform helps you win and increase your probability of winning government contracts. They have opportunities from every federal, state, and local public source in the United States. If you're looking for a compliance matrix, a proposal template, a strategic teaming partner, or details on an expiring contract, BidSpeed can help. BidSpeed is an official partner of the SBA's 7J Management and Technical Assistance Program. Contact BidSpeed at the email or phone number here to learn more. And next, we'd like to thank Government Marketing University. Washington Technology provides a direct line to the contractor executives who need cutting-edge IT systems and solutions to serve the largest customer in the world, the government market. Washington Technology's goal is to help attendees hear from Justice Department leaders, leverage IT to modernize operations, engage in discussions about upcoming initiatives, and analyze how contractors can support their department's mission. Our expert coverage and analysis fuels strategic decisions around partnering, RFPs, and resource development, enabling readers to build relationships, bid smartly, and win contracts. GovExec is ready to welcome you in Tyson's Corner on December 1st. So register today at events.visibo.com/DOJ. So go ahead and you can see that information on the slide there. All right, and we're here today to dig into subcontracting opportunities at the Department of Justice. So let's take a quick look at our agenda. Today we'll start with panelist introductions and close out with legal insights. All right, so our first panelist today, our legal speaker, is Jim Fontana. He's from the law firm Fontana Law. So thank you, Jim, for being with us.
My pleasure.
Thank you. And today, our GovSpend data portion will be covered by Jennifer Schaus herself. So thank you for being with us, Jennifer.
Great. It's wonderful to be here. Thanks.
All right. All right, so next we'll start with the mission statement from the Department of Justice. You can see it there. The mission of the Department of Justice is to uphold the rule of law, keep our country safe, and protect civil rights. So it's always important when we're wanting to do business with a department to look at that mission statement first. And I'll also draw your attention to the various agencies and services within the Department of Justice. Spend some time on each of these services' websites, learn more about their role and specific mission as well. And then lastly, I'd like to draw your attention to some of these important links. First, we have the link to the main department website there, as well as a link to the Small Business Office. Next, there's the procurement forecast, which is really important to understand what the department is buying, when they're buying it, how much, and if any specific set-asides or contract vehicles may be used. And then lastly, that last link there is for the SBA scorecard, which can help you understand the small business contracting trends and what dollars are being won by women, veterans, HUBZone firms, and other disadvantaged businesses. All right, so now I'll hand it over to Jennifer.
Super. Thanks so much, Madeline. And thanks to everybody who has taken time out of their day to join us live. If anyone's listening to the recording, we want to thank you as well for spending time with us. And we hope that you'll subscribe to our YouTube channel and like some of our videos. I do want to thank GovSpend. They've been a fantastic partner over the last couple of years in providing data for us. As everybody probably knows, all of the data that any of the companies that are out there, any of the paid for subscription services, all that data is publicly available. So everything we're pulling today, you guys can go on to sam.gov and pull it yourself in a matter of probably 30 minutes, and your BD folks should probably be doing this. So what we're doing here is not rocket science. The rocket science portion of today's event is going to fall on Jim Fontana's lap, and he'll do a great job of explaining all the legal considerations that you guys should take into consideration. So we want to thank GovSpend, again, formerly FedMine, as Madeline mentioned earlier, for pulling and providing this data, which again is available to anybody with an internet connection and can walk and talk at the same time. So let's go on to look at the first or the top 10 vendors here. Again, basically we just did a simple search on sam.gov or FPDS, check the box for DOJ, and here's the companies that came up with the most amount of revenues. So we're just going to go into a little bit of detail on the first 5. You guys can certainly go through the others at your leisure. So Core Civic is the first one. Let's just stay on this slide for a moment. So the services that they provide are re-entry services to Department of Justice for inmates. They manage correction and detention centers, and they're based out of Brentwood, Tennessee, which is close to one of my favorite places, Nashville. They've been around for about 35 plus years, and they've got over 10,000 employees, half of which are on LinkedIn. So go and connect with them if this is a company that you potentially want to subcontract with, assuming that you've got some complementary services or an opportunity to bring to them. Let's go to the next slide, please. And if you're trying to work with them, you can go to their website, click on the partnership section, and register as a vendor to do business with Core Civic. And let's move on. Okay, so they've realized steady revenues from Department of Justice over the years with a stellar 2019. And you can see that those are millions of dollars. They've got some contracts with DHS and usually averaging half or less than half of the revenues that they see at DOJ. There's a significant increase from fiscal year 18 to 19, and then a big drop, most likely due to COVID. They seem to be growing their DOJ revenues from that point on. Next slide. And as mentioned, they're providing professional services, which are re-entry programs for inmates. And you can, again, jump onto their website, search them on sam.gov, connect with them on LinkedIn, and all of the usual activities that you should be deploying to work with them. And let's go to the next slide, please. Okay, next up is Walden Security. You guys probably recognize the logo. You probably have seen people walking around. They provide armed and unarmed security services or personnel. You've got the link to their website there, and we'll go to the next slide. You can contact them to potentially partner or work with them. Okay, and so as I mentioned, you probably have seen these folks or recognize their logo from the guard services that they provide in various buildings around the country. They've got about $300 million in annual revenues and employ about 6,000 guards. They've got 1,600 employees listed on LinkedIn. They're also a certified women's business enterprise. And let's go to the next slide, please. And they did not lose much during COVID and seem to be realizing steady growth. They're a solid company, also based out of Tennessee. These guys are in Chattanooga. And we can move to the next slide, please. Okay, number 3, coming in third is the GEO Group, with revenues also split between DHS and DOJ, but you've got the link to their website there, and we can go to the next slide. You can register to be a vendor with the GEO Group on their website there. And as I mentioned, yeah, half of their revenues are more or less split between DHS and DOJ. They're headquartered out of sunny Boca Raton, Florida, and employ about 10,000 individuals, half of which you can find on LinkedIn. So they've got about 5,000 employees on LinkedIn, if you do the math. And let's go to the next slide, please. Okay, and their services, the services they provide are design, build, and finance lease of facilities, the intake and housing of offenders, industry-leading in-custody evidence-based programs, as well as secure offender transportation services to the government. Worldwide, GEO Secure Services oversees the operation and management of approximately 82,000 beds in 102 secure facilities and processing centers. Here you can see that they've got some multi-million-dollar contracts that extend for a few years. I think a couple of these, as you'll note the date, will go out until 2028. The bulk of the money is obviously going towards detention services. Again, this is data that anybody, so easy a caveman could do it, but we've put this together for you with the help of our friends at GovSpend. And let's go to the next slide, please. Okay, Constellus. So Centera Group LLC was actually acquired by Constellus, and Centera was providing fire and emergency rescue services. So this seems like it was a complementary fit for the acquisition by Constellus. Constellus is another firm with about 10,000 employees. Half of them are on LinkedIn. And they are down the street from us here in DC, based out of Herndon, Virginia. Let's go to the next slide. You can contact them to potentially work with them. And yeah, they're primarily providing guard services, and the company dates back to 1960. Other services that they provide include canine detection as well as construction. And let's go to the next slide, please. And it looks like their biggest contract is up for renewal this year, or may have actually already passed July 31st. That was a 3 months and 6 days. So yeah, that contract looks like that is their big tiger. So that is the information that we have there on Constellus. And let's go to our number 5 player. Number 5 is Thundercat Technology. You've got your website there to learn more about them. I really like their website. It's easy to use and understand exactly what they do. We can go to the next slide. You can potentially work with them by clicking on the partners link. And just A couple things to note here. Thundercat is a SDVOSB, which is a service disabled veteran-owned small business. They're also a local firm based out of Reston, Virginia, and founded in 2018. So not too much of a heartbeat there, but coming in at number 5 for DOJ shows that they're obviously very successful in a short amount of time. They've got the right contract vehicles, which you can see on their website. Again, very easy to navigate. I applaud them for their website. They provide anything from cyber, cloud, and managed services. They also have diversified their services, and they play not only in the federal market, but also the state, local, and education, commonly referred to as the SLED market. They've got about 100 employees on LinkedIn. It shows that they've got employees that range from 50 to 200, but active employees on LinkedIn shows as 100. The bulk of their contracts are with the FBI and DEA in the millions, and they're making traction in the current fiscal year with boards and divisions. As you can see, they've got a nice start there with close to $600,000 in contracts, again, with boards and divisions. Let's go to the next slide, please, which basically indicates that DOJ is by far their biggest client, at least at the federal level. If you took the next contenders behind that, which would be Treasury, and this is in order, Treasury, State, Navy, Labor, and Interior, and you added up the millions of dollars that they've got with, again, Treasury, State, Navy, Labor, and Interior, it's still, DOJ will still dwarf those cumulative numbers. So I find them to be an interesting company, and you can look at, these columns are going to be showing the fiscal year, with the first column to the right of the department being the current fiscal year, which we're only a month and a couple days into that. So use those numbers as you wish, and we can, I think, move to the next portion, which is going to be marketing best practices. Madeline, I'm going to pass the baton over to you, and thanks for hosting today. And Jim, I'm sure you'll give the audience a great presentation. So thanks, everybody.
Thank you so much, Jennifer, for presenting today. And we'd like to thank our partner again, GovSpend, for providing us with the data. So now I will be going through some of the marketing best practices. So we've listed some of the basics for marketing your services to the top primes. Most importantly, you should use the tools available on sam.gov or on the GovSpend platform to conduct research on the primes and expiring contracts. Use the prime's website, their newsletter, their events calendars, as well as their social media. Learn as much as you can about them beforehand, and then connect. It's really important to be doing that background research. Like Jennifer said, with a lot of these companies, then you can connect with them as well as their employees on LinkedIn. So set yourself apart then and lead with your capabilities, not your socioeconomic status. Make sure that you're bringing a specific opportunity to the prime and work with those SBLOs, the small business liaison officers. They're your advocates. So we've included those links to get in contact with the top 5. So make sure that you take that into account. Now we will be going over legal considerations and best practices. Please note we've covered the federal acquisition regulations on the Department of Justice earlier this year. Actually, our presenter today, Jim Fontana, presented that for us. So you can find the YouTube recording at that link below or find it on our website as well. So now I'm going to pass it on over to Jim. Jim, thanks so much for being with us today.
My pleasure, and hello, everybody. I am working from my home office today, so if you hear a dog barking, that's my dog Maxie, and that means she may or may not be agreeing with me what I'm saying. So please forgive me in advance. You can go to the next slide. All right, a lot of what I'm saying today applies to any teaming arrangement that you would have, whether it's DOJ or any place else, and when I can, because I do work involving DOJ, I'll apply it to that. But a lot of this is universal, and I only have 15 minutes, and I can cover a whole day with each of these 3 topics. So I'll be speaking rather quickly. But I'll try to get as much as I can in, and I'll try to make it as practical. In other words, forget about all the academic stuff. What does it mean to your business? And sort of the how-tos and how not tos and what to do's and what not to do's. You see the three basic issues: teaming arrangements, subcontracts, and compliance. What I didn't put in there, and I'll just make an honorable mention, is a non-disclosure. If you're going to team with anybody, it be in this business or any other business, you do want to, the first thing out of the gate that you want is an NDA, non-disclosure agreement, confidentiality agreement. You want to make sure that anything that you're sharing with your potential partner is covered by the agreement. Now, practically speaking, these agreements are as good as the people who sign them. They are enforceable. Do they get broken and violated and breached? Sure, it happens. The only rule to that is to make sure you cover your bases. Make sure you mark your written material, or if it's online, that you have some kind of legend to it that says that it's covered by the NDA. And foremost, trust but verify. Next slide, please. Just a brief mention on the acquisition regulations that apply here. The CICA is the Competition and Contracting Act, and by the way, I put hyperlinks to all of this stuff and some others as well. But the CICA is sort of the basic statute for government contracting competition. The FAR, of course, as you know, is the Federal Acquisition Regulation. And the JAR is the Justice Acquisition Regulation. Some of the offices within Justice do issue supplemental procurement guidance. I've seen them out of the Marshal Service, for example, the Bureau of Prisons. They'll have certain acquisition policies. They may or may, they typically is not they have the force of law or regulation, as the CICA, FAR, and JAR do. But there are documents that you should pay attention, whether you're a prime or a sub, because it impacts competition, it impacts or could impact pricing, could impact whether you get as a sub or a prime, you get to work at the end of the day. Next slide, please. All right, let's talk about generally teaming arrangements. I think few people in this business don't know about teaming arrangements, where as a subcontractor, for example, you're entering into arrangement with a prime contractor. You may be the only subcontractor, you may not be, but it starts off with the teaming agreement. The FAR doesn't define a teaming agreement. It does define a teaming arrangement in terms of both a prime sub, what I call a vertical. You have the prime contractor on top. The prime contractor is the entity that's bidding on the contract, government contract. And the subcontractor could, again, multiple subcontractors that are subbing to that prime. Or you can have the horizontal arrangement, which is the joint venture, which comes in many forms. They can be two large joint ventures. They could be what we call all smalls joint ventures. If you arrange it properly, two or more small companies could get together, form a joint venture, and still be small. In other words, they won't be affiliated. Their revenues or employees will not be combined. It's just something that you see in the SBA regulations, or it could be what they call the mentor-protege type joint venture, where that is between a large mentor, a small protege. By the way, the mentor could be large or small. And again, you're enjoying the set-asides if the arrangement is done correctly and in accordance with the SBA regulations. If you want to look at it, you can see it at FAR 9601 for the definition, but that's basically what it is. One thing to understand, and this is very important, is the enforceability of teaming agreements. I get this a lot. People say, we got a teaming agreement, can you look it over? It looks fine to me. Or we got it off the web, this is what we want to use. And much more often than not, I'll look at it, and especially with the court decisions in Virginia, and I've litigated a few of these agreements may not be enforceable. It's what some of the courts say. It's not an agreement, but an agreement to agree. And I'll get into that in a little bit. But you have to, one, make sure that, especially as a subcontractor, you want the teaming agreement to be enforceable. Not so much as the prime contractor, but as a subcontractor, you would. And two, you want to have the right agreement with the right provisions, even if it is enforceable. Now, what follows that is the actual subcontract. If there's an award that usually supersedes the teaming agreement. If you have a joint venture agreement, there are not teaming agreements, we'll get into this, but subcontracts within that joint venture, because the joint venture itself is the prime contractor. The partners of the joint venture are actually the subcontractors to the joint venture. They're not actually the prime contractors. Typically, you will see when you have these joint venture agreements, there'll be operating agreements, particularly if the companies that are being formed and the joint ventures are formed as separate entities, typically if they're LLCs rather than incorporated entities. But the idea is to use the right agreement. If you're a prime, you're going to want certain provisions. If you're a subcontractor, you're going to want certain provisions that are not necessarily going to be the same. The terms may differ. Is there a definite requirement? Is it basically an IDIQ that parrots the prime IDIQ? In other words, you sign up for a teaming agreement, but you don't have any guaranteed work share because it depends on the orders that are written from the government to the prime and then from the prime to the sub. Yeah, and you have to recognize as well that not every teaming agreement, any agreement, fits every situation. There's no one size fits all. Anybody can get a teaming agreement. They're all over the web. But the question is, depending on the circumstances, depending on the procurement, depending on the work you're chasing as a subcontractor, depending if you want it to be enforceable and how it's to be enforced, that's going to drive the language, not any sort of boilerplate. Okay, next slide, please. So I broke it down into the various interests between the prime and the sub in terms of teaming agreements. And let's start with performance. This is where teaming agreements tend to be not enforceable. Where there's no mandated work share, just put in the services businesses, the work share, it's all IDIQ, and you only agree to negotiate a subcontract if there's an award. That's the risk of unenforceability. So if you're a subcontractor and you see a teaming agreement that basically says, if there is an award to the prime will commence good faith negotiations with the teaming partner, with the subcontractor, for X work or not defined work. No prices are mentioned, especially if no prices are mentioned. And this is usually in the termination provision, if the parties are unable to, in good faith, negotiate that subcontract after a period of typically 60 days, then either party may terminate the agreement. This is where the courts come in and say, this is not an enforceable agreement, it's an agreement to agree. And mostly because, and I won't go through the legal jargon, the terms are indefinite. It's like being engaged to be married, and before that marriage actually occurs, you're engaged. And if it breaks off, it could break off. And it allows the prime contractor, and this is done rather routinely, to say, you know what, we got the prime, we want you to cut your prices to the bone. If you don't agree, well, then we negotiated with you in good faith, and therefore we're going to go with someone else. The subcontractor complains, everybody lawyers up, and then you go to court, and then the court, in many cases, will say, it doesn't matter because this teaming agreement isn't enforceable in the first place. As a sub, you always want to be careful of that. When you go to the right as the sub, you want to ensure that agreement is enforceable. You want it to require specific quantities, specific work share. And you want that definite language to assure that there will be a subcontract upon the award. So the agreement would say, I'm paraphrasing, of course, if there's an award, there is an award to the prime contract. Thou shalt award a subcontract that will have certain terms, and the work share is defined. It could be a percentage of the labor, which could be dangerous. It could be certain labor categories. It could be a part of the price. There's a lot of different ways to slice that. But the issue is upon award to assure that there will be a subcontract, not maybe, sort of, kind of, we'll see, or after good faith negotiations, and if not, then forget it. That assurance must be there. That definitiveness must be there. I do recommend, when I do teaming agreements, is that they actually attach the subcontract to the teaming agreement. This is what you're going to sign if there's an award. It doesn't work all the time, especially with primes who are not sure at the end of the day. They may get the award, but what if it's an IDIQ, and then on each order they're not going to bid the prices that they bid in the IDIQ? That hardly ever happens. So there's going to have to be some price flexibility. So especially in those situations, it's not always easy to have definitive terms, at least when it comes to price. On the exclusivity side, there's basically two issues. You're on the street or you're off the street. If you're a prime, you want the subcontractor to be exclusive. In other words, you got to play in my sandbox, says the prime. You can't compete, at least on this procurement, with other prime contractors. And it's typically a prime will insist on that. And you see that typically in the service contracts. Of course, the sub wants to keep the teaming options open. Some subs, if you look at it in terms of the product or systems, for example, if it's Microsoft, they don't do exclusives at all. That's one example. But by and large, as a prime, you want to keep that sub on your procurement, on your team, and no one else's team. The prices, as I said, again, being subject to change, that's what a prime would want, that flexibility. As a sub, you want to make sure your prices are set unless they go up, which can be, as I said, very difficult in an IDIQ format. On payment, these are very typical. Now, you might not see this in the teaming agreement. It might something that could be in the teaming agreement that flows over into the subcontract, or it's just in the subcontract. Of course, a prime wants to have what they call a due on pay clause. When the government pays us, we pay you within 5 days, for example. As a subcontractor, you're going to want a net 30 or a similar arrangement. You want to get paid whether the government pays or not. The smaller prime contractors want the due on pay clause, particularly because they don't want to have cash flow issues. If you have a net 30, you're paying your subcontractors in 30 days, you may have a slow paying agency for whatever reason, or there may be a dispute as to the payment. And then you've already paid your subcontractor. So, that's the trouble you get into as a prime. And lastly, and these are, by the way, these are not always these are not all the comparative terms that you would have. These are just the key ones. On the termination, a prime always wants a discretionary termination. In other words, the prime can terminate for convenience the teaming agreement for any reason, and you want to limit that as a subcontractor. That could be in the teaming agreement. A lot of times it's in the prime contract. So a lot of these apply, from the performance standard of the termination, could be in the teaming agreement or in a prime contract. Next slide. You're more likely to get sued if. These are the things you have to be careful about, and these are the things that I have seen over the years that people get sued over. One thing is, excuse me, the agreement or the statement of work, especially the statement of work, is indefinite. It's ambiguous. It's misleading. A lot of times lawyers don't write the statement of work. And a lot of times I see that lawyers don't read the statement of work. They take it for granted that it's just, that's just a work share or something like that. But it is in courts. Typically, your Exhibit A to your teaming agreement or Exhibit A to your subcontract agreement. And that means it's incorporated in the agreement. That means it's a part of the agreement. And if it's ambiguous, then you're going to have a big problem, especially if there's litigation. And a lot of litigation goes on the statement of work not being consistent with the terms of the agreement, and they must be. And I always say, in any agreement, you don't want to buy litigation. You don't want to create a scenario that litigation is more likely than not. And a lot of that comes where you have very indefinite or misleading terms in the agreement, and especially in the statement of work. In terms of undefined percentages or indefinite type work share, percentages of what? Percentages of revenue, percentages of labor. How do you slice that apple? There's a lot of ways to do it, and the best way is to just be clear about it. Of course, there's all the tactical issues and advantages that a sub would have, and a prime, in either wanting certain work, certain labor categories, for example, or not wanting to assign those. Again, the idea is to be clear. As a prime, you don't want to promise what you can't deliver. That's a great way to buy into litigation. You promised us 6 positions in these labor categories at this price, and you're not giving us. Prime would say, well, we lost it, we can't do it. And there's where you get the issue and litigation. And nobody wants to hire lawyers if they don't have to. Or the parties violate, the limitation of subcontracting clause. Both parties can be in trouble for that, and you have to be quite careful in terms of the SBA rules. That if you're a prime contractor in a set aside, that you cannot basically assign more than basically it's 49%. It's called a 50% rule. It's 50+% that the small prime has to work. And it just jumped to bad faith when negotiating agreements. Bad faith can be a real issue that judges and juries take notice of. So next slide, please. Subcontracts, general, the FAR doesn't define a subcontract or a subcontractor. They're basically commercial terms. The government is not a party to it. They rarely interfere in any prime relationships. And I get, why don't you call the government? And the government's usually, they take a step back, and we have no legal relation. They call it privity of contract. We have no legal relationship with the subcontractors, so they don't interfere. It's again, a lot of the principles in teaming agreements apply to subcontracts, the work share, the pricing, the invoicing, all those. When I say the key terms, those are the provisions that you need to pay attention to, and then they're not always susceptible to being boilerplates. Don't forget, as a subcontractor, you can't protest. Only the prime contractor can protest. Subcontractors can file what they call sponsored claims. We don't have enough time to really get into that, but if there is a claim on the subcontractor's work, in many cases, subcontract agreements may have language that allows the subcontractor to step in the shoes of the prime and litigate the claim or the appeal against the government. Next slide, please. Flow down clauses, just briefly, it's basically transferring provisions from the prime of the FAR to the subcontract. A lot of times it's overdone by the primes, like just flow everything down, and it drives subcontractors crazy. And the primes want to they want to limit their risk, and for subs they don't want the increased risk. In many cases, a lot of those flow down clauses they go in the category of who cares. They're not going to apply anyway, so who cares? But keep in mind that only clauses that are mandated to be flowed down by the FAR will apply, or some clauses in the prime contract, typically by statute. So the mandatory ones are particularly the commercial items, the compliance, the employment type stuff. But people don't realize, and a lot of times primes still try to flow down the non-mandatory clause, the termination, the changes, the stop work, the OCI, the disputes. Those are typical commercial items. Don't forget, a subcontract, a government subcontract is sort of a misnomer. They're not government contracts. They're commercial contracts, and they're a combination of commercial terms and the flow downs. That's basically what it is. Next slide, please. Dispute resolution, you don't want disputes. This is, again, how do you buy into litigation? A lot of my practice is prime contractor, subcontractor disputes, whether that's in state and federal court. And a lot of times that's because of miscommunications in the teaming process. and if it ends up in litigation, it's very costly. It's very disruptive to the business. It can cause reputational harm to the business. Again, the government doesn't get involved in that unless sometimes the party will try to subpoena the government personnel, excuse me, or government documents. And you see most of the disputed matters come up over the work share, pricing, enforceability. That's, for the teaming agreement, and costs. There are options for mandatory arbitration, non-binding mediation, or just running to court, or just doing it between the lawyers to solve it. Just to tell you, I'm not a big fan of mandatory arbitration. It means you go to a third-party arbitrator, you actually pay him, you don't have to pay a judge, and there's basically no appeals. And of course, you have your typical provisions and what law applies in what county and what court. Next slide. Okay, and I think this is the last slide in terms of these are the top five subcontractor compliance risk issues. Don't have time to go over all of them, but you'll see the False Claims Act, whistleblower, suspension, debarment, all this and more than this applies to subcontractors. You can't hide behind the prime and say, well, no, I don't really do government contracts, or I'm just the sub and not the prime, or it's not in the subcontract agreement, doesn't matter. Statutes and compliance and liability issues apply to subcontractors in many cases as much as they will apply to the primes. And that's it. Thank you.
Thank you so much, Jim, for all of your great insights and your time, of course. And everyone, this presentation, the slides will be available within around 24 hours after this webinar on slideshare.net. And you can find the recording of this webinar on our YouTube channel as well. So if you are interested, we encourage you to check that out. There's Jim's email there if you have any more questions for him, or you can reach out to us to get in contact with GovSpend. So this concludes the webinar. We look forward to seeing you next week. We'll be delving into the Department of Labor. So thank you, everyone. Have a great day.